But what is copyright infringement exactly? Hi, Attorney Danielle here, and I talk all things tech, business, law, and pop culture. And today we are talking the major copyright infringement case between the family of Ed Townsend and singer and songwriter Ed Sheeran. Let's get started. The family of Ed Townsend, Gay's co-writer, and Ed Sheeran, one of the world's largest hitmakers, found themselves in a major copyright infringement dispute. The Townsend family alleged that Sheeran's hit song, Thinking Out Loud, copied Gay's 1973 song, Let's Get It On, in terms of melody, harmony, and rhythm. However, Sheeran and his co-writer maintain that they wrote Thinking Out Loud independently. The two tracks share a similar chord pattern that the family of Ed Townsend calls the heart of Let's Get It On. Mr. Sheeran and his lawyers never denied that the chords in the two songs are similar, but called them commonplace musical building blocks that have turned up in dozens of other songs. But after a 2-week trial, a jury in New York City ultimately found in favor of Sheeran, stating that the songs did not share enough similarities to constitute copyright infringement. Okay. This verdict sets an important precedent for future copyright infringement cases, as it makes it more difficult for plaintiffs to prove their case. The case was closely watched by the music industry, as it could have had far-reaching implications for the way that songwriters create and protect their work. Overall, the verdict was a victory for Sheeran and other songwriters who have been accused of copyright infringement. And it underscores the importance of understanding the legal nuances surrounding creative works, aka get your legal details in order. But what is copyright infringement exactly? Let's now shift into a discussion on the elements of copyright infringement and what a plaintiff must prove in order to be successful in a civil copyright infringement lawsuit. The elements of copyright infringement. So, in a copyright infringement lawsuit, the person who is suing must prove two things: that they own the rights to something, like a book or a song, and that someone else, the defendant, used it without permission in some way, aka they infringed upon one of the exclusive rights afforded to the copyright owner under the law. So let's get into the first element. To prove the first element of copyright infringement, the person suing must show that they own the legal rights to a piece of creative work, such as a book, movie, or song. Ownership means that the person suing either made the work themselves or got the rights to it from the person who did make it. If they do not own the copyright, they cannot claim someone else has infringed on their rights. A certificate of copyright registration made before or within 5 years of the first publication of the work will establish prima facie evidence in court of the validity of the copyright. If the copyright is transferred to another party, that party is now the owner of the transferred rights and has the right to protect the work by an infringement action. However, courts will insist that the person suing prove the transfer and show how they acquired the rights. Additionally, the person suing must have also been the owner at the time the copyright was infringed. Upon introduction of the registration into evidence, the court will presume that the work is protected under copyright law and that the person suing has ownership rights in the work such that he or she is the proper party to bring the infringement action. Let's move on to element number 2. The second element of copyright infringement is proving that the defendant has engaged in conduct that violates one of the exclusive rights granted to the copyright owner under the law. These exclusive rights include the right to reproduce the work, distribute copies of the work, display the work publicly, and create derivative works based on the original work. Because it is hard to show direct evidence of copying, most cases rely on circumstantial evidence of copying, which requires two elements in itself: that the person being sued had access to the copyright work, and that there is substantial similarity between his or her work and that of the person being sued. Lastly, it's important to note that an independently created work cannot infringe even if it is identical to the copyrighted work. Now, let's switch back to the case to see how all of this ties together. The plaintiff in this specific case alleged that Sheeran had infringed on Gay's copyright for the song "Let's Get It On" by copying the melody, the harmony, and the rhythm of that song in his own 2014 hit song, "Thinking Out Loud." To be successful, the Townsend family would have had to show that they owned the copyright to "Let's Get It On" and that Sheeran had copied the song without permission. The plaintiffs did not argue that Sheeran was attempting to claim copyright ownership. However, they did argue that Sheeran had copied the song. The plaintiffs argued that Sheeran had access to "Let's Get It On" because he had performed the song live in concert. However, Sheeran testified that he and his co-writer wrote "Thinking Out Loud" independently of "Let's Get It On." So, the way copyright law was applied in this case limited how the jury could hear the two songs. The case focused solely on the underlying compositions of both tracks, which include the lyrics, the melodies, and the chords that can be written down on paper rather than their recordings. For older songs like "Let's Get It On," copyright protection is limited to the sheet music that was originally submitted to the United States Copyright Office. In the case of "Let's Get It On," this notation was quite basic and lacked detail. As a result, Gay's chart-topping original recording from 1973 was not presented to the jury. In its place, a computer-generated simulation of what was found on the sheet music was provided to the jury, featuring a robotic voice that delivered the lyrics. "If you feel like I feel, baby, then come on, let's get it on." On the other hand, Mr. Sheeran's studio recording was played several times throughout the trial. So let's take a listen to the sheet music of each song for a fair comparison.
Let's get it on. Let's get it on.
Darling, I will be loving you till we're 70.
But the jury ultimately found in favor of Sheeran. The jury found that the plaintiffs had not proven that Sheeran had copied "Let's Get It On." The jury also found that the similarities between the two songs were not substantial enough to constitute copyright infringement. So, sorry for you. Well guys, that's the end of this video. If you found this content helpful, please don't forget to like, comment, share, and subscribe. But in the meantime, always make sure to do what? Pay attention to the legal details. Bye.